Welcome, everyone, to another edition of Blueprints and Banter. I am your host, Steve Cona, welcoming you to our October edition of this podcast. I'm joined by my fellow co-host, Dave Turcios and Laura Gross. Dave, Laura, welcome.
Thank you very much, Steve.
Dave, you want to talk about our sponsors?
Yeah, of course. So, as always, this podcast comes to you thanks to our diamond level sponsors, which are Gignard Company, Piper Fire, and Milwaukee Tool. Thank you very much for your continued support of our chapter.
So many of you guys know that over the last 5 years, we've been in a legal battle with the city in St. Pete over their apprenticeship and disadvantaged worker ordinances. Over the last month and a half, we've actually got a ruling in that case, and ABC was victorious in that case, thanks to, number one, the efforts of our industry and our contractors willing to fight the good fight for our contractors, and our brilliant attorneys who are here with us today. And I'd like to introduce them: Brian Lambert with Adams Reese and Ric Asfar with Almazan Law. So welcome, Ric, and welcome, Brian. Welcome to the podcast.
Thank you, Steve. We're very happy to be here today to go through the background on this, and we appreciate the invite.
Thank you, Steve.
You bet. So we'll start, Ric, if you want to answer the first question, can you walk us through the key arguments that led to our victory in this case versus the city of St. Pete?
Thank you, Steve. And before I get going, I'm just going to flag that we do still have a pending issue with the city. We're entitled to recover the attorney's fees expended in fighting that fight. So that issue remains open. So I'm going to be a little bit circumscribed with some of the things that I shared today. But as far as the arguments that carried the day, it took a lot of effort, but including an appeal to the Second District Court of Appeal and a remand to the trial court. But ultimately, all of our arguments seem to have carried the day, which I'm really proud of. In the trial court's ruling, it seemed to be consistent with all of the arguments that we put forth, which is that there was preemption in the field of apprenticeship, and that the city was trying to do things that were inconsistent with the requirements for apprenticeships on projects. That there was also an issue with the public bidding, that perhaps the criteria was not as clear as it needs to be, so that the best qualified bidder would always be picked, and it was not clear enough for the folks who were bidding on these projects. This ordinance, which I think is a little bit unique from some of the other ordinances that are out there, had a retainage penalty and a debarment penalty where you couldn't bid on city jobs for anywhere from 1 to 3 years if you did not meet these pretty onerous requirements for having a set number of apprentice hours and in addition to that, a set number of disadvantaged worker hours. That's not my terminology. That was the terminology that was used by the city. And also with some of the wage requirements that the city was imposing, that was found to also be improper. And then, of course, there was HB 53 that came down the pike, and this ordinance just seemed to, flat conflict with that. We had also made constitutional arguments like equal protection and due process. The construction industry was being treated differently than other industries that are trying to do business with the city. And it seemed like every single one of our arguments resonated with the trial judge after we, took it up to the appellate court and came back down and tried it again.
Excellent.
I appreciate that. And Brian, so, Ric mentioned the House bill. Can you talk about how the state law came into play in this ruling and why the ordinance was ultimately deemed to be unlawful?
Sure. So there was already on the books a statute, which is section 255.0992, and that was already out there before we launched into this suit in 2019, but it continued to close in on the city's ordinance power as we progressed through the lawsuit. And the lawsuit, again, like Steve said in the opening, this has been a 5-year battle. So we started 2019. we kind of wallowed a while because we had COVID come into play. We had one judge that actually retired during the time, so we were switched to a different judge. But going back to, so 255-0992 restricted the city's ability to basically tell contractors who they could hire, but it had some outer bounds. It had what everybody commonly calls a loophole, and so it allowed the city to still have discretion where they weren't using state funds, and they were using city funds for projects. And so they were still able to kind of walk through that little, narrow opening and get through that. But as the lawsuit progressed, ABC's efforts on the lobbying side and the legislative side, they went in and tried to narrow the ability of the city to be able to, to make the contractors comply with what they deemed in their political minds, good policy, especially in terms of telling, our folks who they could hire, what the levels were, in terms of the percentage of hours that had to be worked by apprentices or disadvantaged workers. And so, obviously ABC has always been for apprentices, and the problem was they wanted to put so many apprentices on projects because of the amount of hours, that it was monkeying with it was modifying the journeyman to apprenticeship ratio. And so that was improper. And then, as Rick mentioned, they had these issues with retainage where they could essentially keep the retainage if the contractor didn't actually employ apprentices and disadvantaged workers in the ratios that the city dictated in these ordinances. And in addition to that, they had other minimum wage requirements, which required our folks to modify their wages for, the various apprentices and parties that were within the I guess I would say the protection of the ordinance, or the bounds of the ordinance in terms of, who they had to hire and what they had to pay them, which we felt was unconstitutional on a number of different levels. So we had kind of a parallel approach going on. And as we got closer to like 2022, 2023, they started to further narrow 255-0992. And then we were getting closer and closer. I mean, we'd already gone up on an appeal and come back down. We didn't know what we were going to get, but we were at the legislative level. We were getting a lot of changes to that statute as well. So that was further closing that loophole. But there were the three areas that I just mentioned to you. To answer your question, the retainage, the apprenticeship staffing, and the minimum wage requirements, we felt like were probably the main points of these ordinances that ultimately were the downfall, deeming them unlawful.
Appreciate that.
So, Rick, next question's for you. We know that this probably won't be the last time a municipality tries to put in an ordinance like this. So from a legal perspective, what advice would you give any other municipalities trying to implement workforce development initiatives to make sure that they're not violating the law?
Thank you for that. And I would say, there's a lot of things that I could say. I think this ordinance was really a bridge too far because it had, three components. It had the apprenticeship piece. It had the quote unquote disadvantaged workers piece. Again, their terminology, the city's terminology, not mine. And then it had the wage piece. And all of these pieces where it set minimum requirements for, apprenticeships, disadvantaged workers, and wages to be paid to these groups, they were all backed up with a penalty. And so that for me was, I mean, it's all significant, right? Because ultimately we had our day in court and the court agreed that we were correct on all of the bases that we argued. But the penalty for me personally was just something that I found to be really, really problematic. If a city wants to advance policy objectives, by all means, advance policy objectives, but doing it at the cost of the industry, where you're going to lose your retainage and possibly more, and you're going to be barred from bidding on city projects. That seemed to be one of those things that it was punitive, and it was punitive designed to really compromise the industry. And I think that, I think all of it was problematic, candidly, but I think the penalty piece of it was really extremely problematic. And so my suggestion would be maybe avoid the penalties. Maybe incentives would be a way to advance those policy objectives in the future.
Thank you.
It's funny because the biggest thing that we had to deal with as an association was the PR campaign, where we were battling the court of public opinion when it came to apprentices and disadvantaged workers. We're all for people in the construction industry to work in construction. We are one of the largest providers of apprenticeship training in the state. But we thought as an organization, that this law was something that we needed to challenge because it actually limited the amount of competition that we saw on these types of projects. So Brian, we had to balance like our facts versus their emotional arguments that the city was making. And how did you guys combat that?
Well, I think number one, legally, on the legal side, whenever we were challenging, I think we were correct. So the city didn't really have, you talk about the court of public opinion, and that was definitely out there because they were painting ABC as the bad guy, because they were saying, well, look, ABC is trying to say, oh, they don't want apprentices. And that's not what we were ever saying. That's kind of what I touched on before. We had to get out there the fact to the judge and the public jury, I will call it, the fact that we want apprentices. ABC has apprenticeship programs, and it has always. And we just can't, do it the way that the city of St. Pete was wanting it, because it doesn't make practical or legal sense. It required almost 1 out of every 3 hours on a project to be performed by apprentices, or what the city termed disadvantaged workers. And that is an incredible volume of work for a contractor to have to staff and manage, and then be able to report it back to the city that they had complied with it. That was another onerous point that that was another byproduct that these ordinances created. It didn't just create, it didn't create jobs. They were trying to force staffing decisions that are best left to our members. Who better knows how to build a project than our members? They don't need to be told how to, who they should use and how many hours these people should use. And ultimately, our members were also held to a standard to where, we warranty this work, and we have to, for the long term, if there's something that, has gone wrong, they would have been compromised. They were compromising our best business decisions in order to properly build the projects that they were seeking, such as the pier and a lot of these other really larger jobs. If you didn't comply with these onerous requirements, like we said, you would lose retainage and you would be subject to debarment. The ramifications, we had dealt with the city, in several occasions before they put these ordinances in place. And then afterwards, we even went to them during the litigation and said, hey, why don't you change these to an incentive base? And they had already decided, look, we're not going to do that. Basically they were politically too far into it. And so I felt like they had painted themselves in a corner on their own behalf, nothing that we had done. And so it left them, with no options other than to bring this suit. And so at the end of the day, there was too much. I think Rick mentioned, a bridge too far. And there was a lot of different ways that they could have approached this. And we even tried to work with them on approaching it, and they refused. And so that's what led us to where we are. But ultimately, I feel like the court probably sided with us. I can't be in the judge's head, but I think the judge simply, was able to see right from wrong. And that's what wound up, getting us to where we are now.
I appreciate that. Rick, what is your opinion? What can other contractors and builders take away from this case in terms of protecting their rights under the state law? What would your advice be?
Appreciate that question. And I think at this point, if there's a suggestion I can offer to people in the space, in the industry, be vigilant. Keep an eye out. If something doesn't feel right, talk about it. Talk about it with your colleagues in the space. Talk to your trade groups. ABC has been wonderful with supporting the industry, obviously, for a very long time. And it was one of those things that I think in this situation, it kind of highlights exactly how it's supposed to work. If there's overreach in any way, shape, or form, you share it with your trade group. And then to the extent possible, your trade group addresses it. And I got to give ABC a ton of credit for how y'all addressed it. Honored to be, invited to the party to help, get this one on the rails. But, just be vigilant, talk to folks. And if something doesn't feel right, see what we can do to address it appropriately.
Well, Brian and Rick, I appreciate all of your hard work. We still have some work to do, obviously, in this case, but your efforts were amazing, and we appreciate the work you did on behalf of the association. So on behalf of all of the members of ABC, we give you a big round of applause and thank you. And I do want to kind of have an open discussion with everyone here. This is a big deal. This is a big deal for the state. And Dave, you sit on the state board. Laura, you hear from all of the members. St. Pete's going to have a big project. They have almost a $1.3 billion race stadium that they're going to be building. And I'd like to thank the St. Pete City Council for approving that, and all of the local leaders in Pinellas County for approving that deal. It's going to generate a lot of work for the construction industry, and it's going to put a lot of people to work in Pinellas County and all over the state. And the ramifications is that Florida is free and open for people to work, and having this case set precedent. And I want to thank also our board of directors 5 years ago for taking on the financial obligation to fight this. Initially, we didn't think we were going to be fighting it for 5 years, but with COVID and other things that happened in the legal system, this was a big lift for our association to challenge this. But I think looking forward, I think this type of ruling that we were able to get really makes it Florida the state that we want to do business in. And I don't know what your thoughts are on this, Dave or Laura, but and how it can help us as an organization make sure we tell our story that we are fighting for the industry.
Yeah, no,
I think. Sorry, David. Go ahead.
Go ahead, Laura.
I was just going to say to Rick's point about, it's one of those things, if you feel something, say something. Since this has happened and the rulings come down, there have been other members that have reached out about other municipalities trying to put in similar ordinances. And they know it just doesn't seem fair. It's not just, it's making work being done a lot harder. And so I know that for our members, they're feeling a lot more comfortable to reach out to ABC and say, hey, how can you help us? And is this right? Because it doesn't feel right to us. So I think it does provide a little bit more comfort for the contractors to know that these are things that ABC specifically is going to have your back on, and you're not fighting it alone. It's not just one contractor fighting a municipality. It's a conglomerate of contractors fighting for that.
Yeah, and the only thing I was going to add is first, in regard to the financial commitment required to fight this case, I think we should also thank ABC National, who did pitch in and assist with that tab. They definitely deserve credit there. To Laura's point, it's one of the things that ABC does. It's a good place for ABC to be. It's better for ABC to take on this fight than have a contractor take on this fight, because obviously that could jeopardize their relationship with any municipality. And I also just wanted to comment back on. I have a lot of comments. I want to comment back on when it was talked about earlier about we were fighting the court of public opinion. Two things to that. So A, there isn't a contractor in this state, probably in this country, that isn't thirsting to hire individuals, qualified individuals. So, to put any kind of pressure or think that an ordinance is gonna make contractors hire more people, contractors are starving for individuals. So those kinds of things aren't really necessary. I also want to make sure that it's understood. I don't think any elected official pursues office and when gets voted in decides to pass ordinances that just want to make lives harder for any business owner. I think they had, the people who try to pass this, I think they had the right intentions. It's just what happens a lot of times when laws are passed, and we see this in so many examples every time we go in some kind of law, because the law that is implemented or that's in place has unintended consequences, and so that's where ABC tries to step in and help not only all the members but the whole construction industry as a whole.
So wrapping this up, we want to be available to our industry and do these types of things, but back to Laura and Ric's point, we don't know what we don't know. So we have a lot of members who are always telling us things. But if you see stuff around the state that just doesn't look right, we have the opportunity. We have state laws in the books. We now have this ruling that really help us move the needle when it comes to fighting for the industry. Ric, Brian, any final thoughts? And then we're going to close up this edition of this podcast.
Yeah, I think I congratulate you guys on this victory, number one. And then I also say, I echo a lot of what you said. What Dave said in terms of legally, we can stand behind the name of ABC instead of putting, your futures in jeopardy with other potential employers. So that is really a great backdrop for you to have as part of your membership, because we have that ability as an association to have standing to go in and challenge these things. That is how we did that. We did not have a single contractor member that was named in the lawsuit, even though we did have a few that were aggrieved during the time frame, and that was actually brought up. I think that party was having issues at the same time whenever we were making the decision of whether or not we were going to go forward with suit. And so, but we didn't have to, because like I said, and the law sees it as us having associational standing, so we can bring suit on behalf of our members without actually having to have name a specific party. And then I think that this ruling puts you guys on the map, because I think there was, the other side story that's going on is, while this is proceeding in the past 5 years, we had other counties and cities in and around the area, in our local Tampa area, that were saying, oh, you know what, that looks good. So I think we'll do something similar. And I think they kind of just did that with blinders and didn't realize that we were serious. And so the ramifications for that is now, ABC is not someone to be taken lightly. And so we are whenever we say, hey, we want to work with you, and instead of working against us, take us seriously, because we want the best for everyone. We want the best for our members, number one, because that's what this association is for. But we want to play a fair playing field. So I think it was a long fight, but you have the benefit of that now. Other people, all the municipalities saying, okay, let's take notice of this.
Rick, final thoughts, and then we're going to wrap it up.
Appreciate it. And yeah, I think Brian put it very well. I think everybody who has spoken has put it very well. I think everybody's very well intentioned, and sometimes it's just everybody's well intentioned. Something happens, and then as things kind of progress, you kind of see, well, maybe this needs to be adjusted or that needs to be adjusted. And very thankful for the opportunity to serve as a voice for ABC. Very thankful for what you guys do for our community, the state, and beyond, as an advocate for the industry, and to make sure that these things are really going forward in a manner that is really in everybody's best interest. I think having properly staffed projects with people who want to come in and work, and with the right number of apprentices and folks like that, is going to be something that's going to be great for the business and the business community, for the local governments, and for the citizenry. I think that ABC's membership is going to do a wonderful job with some of these really large projects that were mentioned, and I think they're going to serve the community for decades, and people are really going to enjoy what comes out of that. And I think that making sure that the laws are there to support appropriate staffing is going to be a really wonderful thing for everyone. So, sincerely thankful for everything, and thank you for the opportunity to share.
Well, thank you all for joining us today, and thanks all the members for listening and following this podcast. You can like and subscribe to it, Blueprints and Banter. It's where all of your podcasts can be found. So go to your favorite spot and like or subscribe to our podcast. Thank you all for joining us today, and we look forward to seeing you on the next edition of Blueprints and Banter. Take care.